going to move to the final plea calendar, indictment 23, SC 1869007. Marquisha Knox.
Judge, she is present today. Person time just to go.
All right, let's go to position number 2, indictment 22, SC 185436. Jawan Gaston. I don't see Ms. Rondon, so we'll come back to that. Position number 5, indictment 24 SC 001933. Javion Outlaw.
Good morning. Cameron Matthew, Mr. Outlaw.
Is he present?
He,
Okay.
and Your Honor, this is on for final plea, and we have a negotiated plea. I was in the middle of completing paperwork when Your Honor came on the bench, so if I could finish.
Go ahead.
Okay, thank you. That'll give me enough time to go call my victim on that other case.
Ready? Okay. Not a problem. We have other cases. Two. Position number 6. Indictment 24 SC 001711 Beverly Range. Ms. Rondon. Okay. Let's try position number 3, indictment 22 SC 185439 Aquila Carter.
I expect him today.
All right. Position number 4, indictment 24 SC 001756 Deshaun Hodge. All right. Mr. Marquez, you represent the state?
I am, Your Honor.
Okay. Good morning, Mr. Hodge. This is indictment 24 SC 001756. Ms. Jones is present representing Mr. Hodge. Mr. Marquez is representing the state. The calendar reflects we're here for a final plea. What are we doing, Ms. Jones?
Mr. Hodge is going to maintain his not guilty plea, Judge.
All right. Any outstanding issues, Ms. Jones?
Not that I can think of right now, Your Honor.
All right. Right. With that being said, you will be put on a trial calendar and be notified accordingly. There's nothing further. All parties are excused.
Yeah.
All right, we'll go back to that.
Judge, can I have 2 minutes to?
Sure. Is Attorney Lewis present in the courtroom?
I'm sorry, no.
Lewis?
Yes.
Okay. Before you arrived, the state announced that on indictment 22 SC 182298, Janice Dillard, that they are going to null process that case.
I of course, you know I know this. It's good to see you. I saw you. Yeah, I saw that you were next to. You told me something else.
Of course.
Judge, is it possible to have this matter sealed without the formal motion? I can do that.
As long as the state isn't objecting, so you can get with the state.
Okay.
Mr. Marquez has stepped out, but you can send him an email or follow up.
Yes, ma'am.
I don't think it'll be a problem since they're not proceeding.
Yes, ma'am. Sounds good. Thank you, Judge.
All right. There's nothing-
Thank
I was just about to say, unless there's something further, all parties are excused.
you. Okay.
You too. Deputy Hudson, let me know when something's ready.
Opinions today.
All right, Mr. Gotti, whenever you're ready. And everybody, I'm just going to give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
This is back number 22 SC 182, 183 572, state of Georgia versus Mr. Miles Army. Probably will be raise your right hand. You solemnly swear affirm the testimony about giving matters pending before this court will be the truth, the whole truth, nothing but the truth, sir. If so, and put your hand up. Could you please say the true, correct, and legal name for the record? I'll let you sign for asking all questions.
And Mr. Gotti, maybe reposition the mic while he's doing that.
Yes, sir. Farley, did you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No? Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No? And how old are you, sir? How far have you gone to school? You see it? Are you able to?
Also speak into the mic, please.
26 and got a bachelor's degree. So are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183 572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is possession of firearm with Christian felony. You understand you're currently charged or indicted with those counts. Yes. And you understand you have the right to plead not guilty, guilty or not guilty to these charges. And if you plead not guilty or remain silent, you may receive a jury trial. Yes. And as your attorney, Mr. Menendez gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment? So waive. Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing? Yes, so waive. And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to? Yes. And he advised that for count one, RICO, the minimum is 5 years, the maximum is 20 years. Yes. And do you have any questions as it relates to that count? The single count you'll be pleading guilty to? No. And so do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count you're pleading guilty to. The court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum of the charge. Please. Do you have any questions about that? No.
Is he just pleading to count one and y'all are not processing the rest as part of the agreement?
That's correct.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing of other convictions in this jurisdiction as well as in other jurisdictions? And do you also understand that if you're not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else? Yes. Do you understand that you waive any and all defenses by entering a plea of guilty today, sir? Yes. Do you also understand that by pleading guilty, you're giving up and waiving the following rights: the right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to assist the counsel hired by you or court appointed you unable to afford as an attorney for the trial of your case, the right to presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right that the charges proved against you beyond reasonable doubt at the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights? Yes. And Ms. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? No. And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that is in your best interest to do so? Yes. And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alabama, the court accepts this plea of guilty places you in the same position as if you were convicted after a jury trial? Yes. Okay. And how do you plead count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, and indictment number 22 SC 183572? Guilty on the answer. And Mr. Farley, is this Alfred a guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to? Yes. Do you understand that you may have a limited right to appeal this guilty plea conviction? Yes. Do you also understand you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, sir.
Well, I want to make sure.
Yes, ma'am. Sorry. You also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court, to file a motion seeking to withdraw this guilty plea, which doesn't mean the court necessarily granted or not. It's just that's the time constraint you have to file under those areas of the law. Yes. Okay. Do you have any questions about that? No. Okay.
All right, and your attorney, Mr. Menendez, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Just for the record, clear, I just provided first appeal, the indictment was signed by all parties as it relates to the defendant's guilty plea to count one, conspiracy to commit RICO. Your Honor, had the case proceeded to trial, the state would show beyond a reasonable doubt that between January 24th of 2013 and May 8th, 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise being YSL, doing so by protecting power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association.
All right, I assume some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago. All right, so I'll take that into consideration with regard to the factual basis. So, all right, anything else from the state?
Nothing further. The recommendation as it relates to the joint recommendation that the party would make to the court. It's my understanding that the defendant obviously would like to attend his plea in North Carolina as Alfred, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender treatment, and he is asking the court treat him as a first offender, which the state has no objection to either, and the recommendation would be 5 years to be served on probation.
All right, Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Mm-hmm.
All right, and have you all discussed the potential upsides and downsides of that?
Mm-hmm.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon. Understand?
Mm-hmm.
All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, then not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alfred. Do you understand that? All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, sir. I just want to add a little bit of nuance to the plea. In case the court's not as familiar, there's a lot of it on the front end.
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work. Yeah, it's not on your end, it's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. I'll look at what's in the chat. Okay, thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then get the warrant out to everyone.
Yes, Judge. The defendant stands before you having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator among 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Terrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated, and I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Let me pause you for 1 second. He thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Mr.
Yes, Your
Kendrick.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'll call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background. It's on a body camera footage. They were able to secure a statement from Mr. Kendrick. And
from Mr. Kendrick or from Mr. Wimberly?
Both. But with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery, and I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation in criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior action. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor, 15 SC 140116. And it does appear that he was on active probation for that particular case, having been sentenced to 15 years to serve 2 sentences with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents, one in custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence, and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. In many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both the correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. But I agree that he should have been in possession of a weapon in the jail. But those are the allegations that have been put forth in this particular case. And every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, I pointed him to being the perpetrator of the assault. And so, I certainly understand everyone's talking about the conditions of the jail. Exhibit A is before you as to why it's unsafe. So, Judge, we respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for management, frankly. I mean, just Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. So is it safe to assume that your office has filtered through that and we've got the 2 cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay. So they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation of bond hearing process. That's your best forecast, with maybe one exception. That's right. Okay. All right. Thank you. Thank you. Ms. Bumpus, want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. Certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago, and minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but it doesn't mean wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case, so they're not two separate crimes.
Okay.
This 2015 is the federal
All
case.
right, so there just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. So there's supervised release. That's what they call it on the federal side. It may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well once that warrant is addressed, or if it's lifted, or it's dismissed, or the judges tend to set bond on probation warrants. But if so, then we don't need to reconvene this session. I'll know that warrant's out of the way, and then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence, and that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because it's fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state, but what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff, and you need to decide what you can deal with, but it doesn't help anyone to just keep bringing you and Mr. Kendrick back, like, all right, this time it was a cell phone, this time it was a cheeseburger, let's just wrap it all up, if that's what's going to happen. And I trust Mr. Rao's going to look into that, and they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone said, oh, he was a saint when he was in jail. And they said, well, not so much, he was a saint who ate cheeseburgers. Okay, and we worry whether that's a big deal. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015, because it would be that state probation. Okay, Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case, don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
Pretty much understand that.
Okay. All right, well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant, or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured, so I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these two cases.
And Your Honor, how am I gonna, can someone email me about the probation? or-
I will keep everyone in the loop.
Okay, thank you.
Okay. All right, Mr. Rao, anything else from the state? All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
Thank you, Your Honor. That's my business, ma'am. Thank you.
Yes, ma'am, thank you for being here.
The immunity motion? No, okay.
Oh yeah, Shannon is up. Shannon is up. Shannon is up.
He's the complaining officer, Your Honor. No problem.
Tay, stop doing that, mama. Mm-hmm. Yes. I'm gonna go back a little bit, y'all.
Back on the final plea calendar with indictment number 1, 22 SC 181814 Shannon Jackson. His attorney is present. And the state is represented as well. We also have indictment 22 SC 185532 and indictment 23 SC 188183.
Your Honor, before we get started, may I approach with something off the record?
State has to approach as well.
They gotta go in the closet to approach. Taylor, don't do that. Girl, you ain't never sung that song that loud before. Get your microphone. So Shannon is up next. Looks like Matt's and the state just went to do an approach with the judge, and it looks like they're meeting in a closet. I'm trying to check all the channels right now. I think what messed up Miles' situation is that he was apparently or allegedly stated to someone to get rid of a weapon for him or something like that. What's your phone? Your password. So we're just waiting now for Max to come back out. He is in the back speaking with the judge, and now it looks like Kayla is now in this courtroom. She just left the courtroom with Yak. So the whole issue with Yak is that there's apparently some kind of warrant out for him for one of his charges. And the judge was basically saying that it'll be pointless to do a bond with the active warrant because then they'll be right back in. So he has not decided on if Yak will receive a bond or not. Sit down. Uh-oh, you okay? Sit down. Sorry, y'all. I'm in mommy mode at all times. My baby is with me at all times. She got her little bed back there to y'all probably. You're welcome. You gotta be quiet so you can hear Moana. Sit down. We're just waiting, y'all. We're waiting for Max to come back out. I have not seen Shannon. I haven't seen him yet. I got about 11 more minutes to be on live, so I'm hoping they have this wrapped up by then. But Max is in the back with the judge and the state. Max asked to approach. Shalea, please don't start her. She's never sung that song that loud. I've been trying to sneak and record her, and she's here now screaming today. I'm going to check back on the other defendants. That's what I told my dude, like, until while I don't have her in daycare, like, I'm never going to be able to stream. All right, so it looks like we're about to get back started. Sit down, Mama. We're finna get back started. Oh, well, get your passes.
We're back on the record when you defend Mr. Jackson out, please.
All right, y'all. So Shannon is about to come out. What you want? Looking for your passing? You're welcome, baby. Lee, I'm already over here with a migraine. I'm nervous. I've never done a stream before. I'm just nervous. Who is this dude? We're not here for you.
Good morning, Mr. Jackson. As you stand before me today, you are here on 3 indictments. Indictment 22, SC 181814. Indictment 22, SC 1855532. Indictment 23, SC 188183. My understanding and consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, you're going to be entering a plea guilty to certain charges in these 3 indictments. So if you will, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God. I need for you to tell me your name and spell it, please.
Shannon Jackson.
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand? All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand the case proceedings? And how old are you? This is part of the education that you've gone. Can you read, write, and understand the English language? And you're a little soft-spoken.
They just started back. So if you've been hopping around like everyone else, Miles took an Alfred plea, 5 years probation.
With possession of a Schedule 5 controlled substance, possession of a firearm during commission of felony, possession of a firearm by
They haven't made a final decision yet because he has a warrant.
the possession of a Schedule 5 is up to 3 years in confinement.
Yes, sir.
And they don't want to give him a bond, and then they bring him back in and says that he has an active warrant and he's right back locked up.
You understand the maximum possible punishment on possession of a firearm is up to 10 years.
Yes, sir.
Now, you're also charged with resolving today case number 22 SC 1855532, which you're charging count 1 with serious injury by vehicle, count 2.
They got my boy in the prison blues.
Count 3 that by taking, count 4 failure to maintain insurance. Do you understand that as count 1 the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
You understand that for the entry auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And you understand that for the theft by taking based upon what the amount alleged in the indictment, that being granted $5,000, less than $25,000, the maximum possible punishment for that offense was up to 10 years in confinement.
Yes, sir.
And you understand for what failure to maintain insurance is a misdemeanor by up to 12 months in confinement.
Yes, sir.
Now, as to case number 23 SC 18818, we're charged with counts 1 and 2 with participation in criminal gang activity. 3, possession of methamphetamine with intent to distribute. And counts 4, 8 with possession of prohibited items by intent. Do you understand that for those counts 1 and 2, the gang activity could be sentenced up to 20 years in confinement?
Yes, sir.
You understand for the possession of methamphetamine with intent to distribute could be sentenced up to 30 years in confinement?
Yes, sir.
And you understand the maximum possible punishment for those prohibited items is up to 5 years in confinement? Yes, sir. Now, do you understand you have the right to plead either guilty or not guilty to any of trial in which the state would
reasonable doubt.
Yes, sir.
Now, as your attorney, I'm going over with you this form that I'm holding, plea of guilty, ultimate waiver of rights.
Yes, sir. I'm on.
And you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Sharp, are you waiving any potential defects in this indictment on behalf of your client as well as formal reading of the indictment?
So wait.
Okay. And Mr. Jackson, do you need any more time with Mr. Sharp? Are you prepared to before this time?
No, sir.
Now, in relation to this particular case, I believe
You gotta love Max.
do you understand that if you enter this plea, that this also can be used in the future as what we call recidivist punishment, which means that if you got trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. You understand that?
Yes, sir.
You also understand there can be what we call collateral consequences to this plea. What I mean by that is that this can have a negative ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And you understand this is a negotiated plea of guilty, which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. You understand that?
Yes, sir.
Now, do you also understand that if you are under probation or parole, that this can have a negative impact on your probation or parole status, and be clear, this would not have a negative impact on the offense for which you just were sentenced, as all these offenses occurred prior to entering this plea.
Yes, sir.
You also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms, which also include not possessing a firearm. And the possession of a firearm aside from a probation violation also would act as a non-sentence.
Yes, sir.
Now, do you also understand that there can be, you understand that you're waiving any and all offenses, including any mental health offenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights. Ask if you understand you're waiving all of those rights. That's okay. Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Understand.
Now, as an enforcer who threatens you or promised you anything to get you into entering into this guilty plea. Now, your attorney has worked out certain cases in which, in certain counts in which entering a plea of no contest, as well as Alfred v. North Carolina. Okay.
Yes, sir.
So I'm going to go over each of these indictments specifically as counts. Do you understand Alfred v. North Carolina is a situation in which you're not admitting that you are in fact guilty. However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter that. You understand that?
Understand.
All right, so we're going to begin with case number 23 SC 18818. You understand you enter a plea of no contest as to the participation in criminal street counts, which is 1 and 2.
Yes, sir.
You understand you'd also be entering a plea of Alfred v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute, the possession of prohibited ice pipe.
Yes, sir.
Now, do you understand as to case number 22 SC 18814, your attorney has requested and the state is not objecting to an Alfred plea as to the count 2, possession of a firearm for commission of felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 18532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you don't have a I take it better maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and were standing in place, that fairly accurately summarized the counts, which are the no contest as well as the wrong. Yes, sir. Understanding all of that, how do you wish to enter your plea?
Good.
And clear that the guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony,
theft by taking and failure to maintain insurance, is that guilty? As to the 22 SC 1814, which is the possession of a controlled substance, possession of a firearm, murder, commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alpha v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2 of participation in criminal street gang. What is your verdict, or what is your plea?
Okay.
And the counts 3, possession of methamphetamine with intent to distribute, and the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the F.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And you understand that for the felonies, you would have up to 4 years to the date is to file the call habeas corpus, and that's if you want to challenge the constitutionality of this plea.
Yes, sir.
And you understand that there is one misdemeanor on here, which is a failure to maintain insurance. You understand you would have up to 12 months from the base date to also file the habeas.
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission. That vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge,
Imagine you see somebody get in a car accident and you stop to help. And when you stop to help, they hop in your car and drive off.
The state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and possibly tested, possibly alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle. Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. The judge, that was a shared cell, and located inside of that cell included a cell phone. The pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending on what date it is at Rice Street. And Judge, possession of AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served.
as to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10. The count 2 is going to be 10 to serve 3 community time served balance on probation, as opposed to 10 years probation.
I'll refer to you as you were the one actively involved in the negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again, and for the record, for count, for 22 SC 181814, count 1.
Is possession of controlled substance, that would be 3 years community time served. Count 2 would be 10 to do 3 community.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of felony, is a mandatory consecutive. So you would have count 3, the possession of a firearm at some period of time, just statute minimum 1.
Okay, so I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 community time served, balance probated. And count 2 would be 5 years probation consecutive. The difference, Your Honor, is in essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3 community time served balance on probation. Count 2, 5 years probation consecutive to count 3.
Yes, right.
And count 1, 3 years to serve community time served.
Correct.
Yes, sir.
I love her hair.
You may continue.
And as to case number 23 SC 188183, as to counts 1 through 8, they all would need a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of the sentence. He has to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There's to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there's to be no possession of a firearm on his person in any vehicle in which he occupies or any residence. Quite frankly, there's no possession of a firearm, given he would be a convicted felon. Judge, I also understand.
That's what it's looking like.
About concerns about being able
I need to look up that case number he said, though, to see which case he's saying that he can't contact nobody from.
to an exception for the Atlanta airport. Judge, this is the only case that was.
But they said he banned from Metro Atlanta. So basically, Atlanta kicking everybody out.
And so, Judge,
We ain't coming if y'all kicking all them out.
This is why I am consenting to a no contest on counts 1 and 2. This is not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship that I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, I was had some incidents, unfortunately, in jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist. This is irrelevant, frankly, whether or not we will be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of a larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation had this proceeded to trial, but this was in fact a shared cell. Judges, it's been in the past occasions where other individuals' contraband can the fact he found in other individual cells, as well as the fact that there was a shared cell, so there's other individuals with that access. And judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that would have demonstrated possession or control or intent over the narcotics or objects inside that cell, we probably would be in a different situation. But I'm not going to hold Mr. Jackson at Rice Street or asking to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I want to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank you. So will you go over the special conditions again, so I make sure I have them correct?
Yes, sir. The special conditions would include banishment from the metro Atlanta area, with exceptions for the Atlanta airport. Judge, that would also include that he is to maintain gainful employment while on probation. There is to be no contact or communication, directly or indirectly, with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept his as a probation, correct? Okay. Anything else?
Nothing from the state at this time.
All right. Anything from defense?
Your Honor, I'd just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment.
Talk that talk, Judge.
From the metropolitan Atlanta area.
He is. Your Honor.
Okay.
He's the serious entire.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? The state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do that outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer for this court.
Your Honor, I anticipate that at some point in the future, there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, and maybe we can revisit.
That man got a whole grandma here that's like a mother, his father, his kids.
Yes, but you have to tell us who you are for the record.
I'm Judge Jones, Officer Jones, with probation dismissed. Due to the fact that where he's going, they not accept these cases, we have to come in front of the judge to our proceedings. I I don't know that right now. And I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get this situation. It's what I did, but he won't go.
All right, thank you.
What? What she said?
So essentially what she's saying is until the state that you are moving to accepts your probation.
Nah,
Here in Atlanta, and
nah,
everybody knows that's
nah.
not in the metropolitan Atlanta area. Okay. All right,
Okay.
as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right, so we're going to start with (22 SC 185532). The negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve 2 commuted to time served. Balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent with count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume it's not related to any of those co-defendants.
Sure.
All right, okay. So the people who used to be your friends or the ones that you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. My understanding is you were assaulted while you were at the Fulton County jail, and unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out in 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems. Because you've shown you can do that because you've matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years, and nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they signed off on it. You are to not have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572. So you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentence sheet, that all these sentences are run concurrent with the sentence that Mr. Jackson has from 22 SC 1835.
Any objection from the state?
No, Judge.
Okay, so all the sentences from 22 SC 1814.
So what this means is all of his probation is concurrent on the RICO trial.
23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record to say anything? Oh. She can't hear you.
I'm sorry. Unless you want me to tell you.
Yes, just put it all on the record about recording.
Okay, so we will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303.
So, don't be late. Don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Sure.
All right. So at this time, is there anything else from either party?
Just Mr. Sharp recommended I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exception.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you.
All right. If there's nothing further, then all parties are excused.
Thank you.
Business after probation is done in the
Yes. All right.
Position 7 on the final plea calendar,
Hold on.
Y'all, that boy's so happy.
position 1 on the final plea calendar.
Yeah.
All right. Position number 1,
You got it?
indictment 23 SC
Good job.
186907.
Get that one.
Knox.
I'm gonna cut it off once he X's out.
Sorry, Judge, Ms. Knox needed to.
All right, y'all. So I'm about to end because y'all know I got a job and I've been on here too long. But so for right now, Yak is not out. Yak is still kind of up in the air because he had a warrant, which makes sense. They want to get the warrant taken care of because if they release him on a bond and he has an active warrant, he's going right back into jail. So that's a short. So they want to handle that first. Shannon is coming home today. So what they're saying is that Shannon has office time is going to run concurrent to the time that he got with YSL. So it's not going to be any extra add-on probationary time. However, he does have a ban from Metro Atlanta, but it's only a 5-year ban. All right, that's a 5-year ban. So that's basically half of his probationary time. He has that 5-year ban, and what else? Looks like he's gonna be living in Texas, maybe. While we were watching, I did look it up, and Texas does have a little bit stricter policies and rules on how they accept people to kind of switch over with the interstate probationary thing. However, they do accept people. So yeah, look like he's about to move, but they are going to allow him to be in Atlanta until he gets everything figured out. I gotta double. Oh, I'm sorry, baby. I'm so sorry. I have to double check to see what his warrant is for. Someone stated that the warrant came from the charges that he possibly picked up, but that makes no sense. Shalea, do you know what the warrant is for? Because that makes no sense whatsoever. I gotta go make my video for TikTok. My head is throbbing. But in all honesty, I know a lot of people say that she's kind of harsh. I feel like she's harsh within her own rights. Most of the stuff she told him is harsh truths. A lot of people want stuff to be pacified to them, and that just ain't how stuff works. Like when you are applying for jobs, like I help people. I sit here and volunteered and help people find jobs that could not find jobs for free. And those employers are not trying to hire you if you don't, have some type of education. A GED is great. I know somebody who has a GED is making a lot of money. A GED is great. High school diploma, college education, like they want to see something. They want to see that you're not quitting on everything in life. Nobody wants to hire someone that they feel is a quitter. So she told him, right, it's harsh truths. The people that involved in the case, some of them are not trying to do better. And I'm just going to keep it 100. Like if you follow a lot of different people on Instagram and stuff, some people are still caught up with what's going on. You know what I'm saying? Like sometimes you got to cut people off. But so the other 5 YSL defendants, it does not look like the other 4 took a plea. They were offering Damikion Garlington like 30 years. 30 years. The warrant, she said she thinks the warrant is for a probation violation. So you know when you're on probation, for most states, if you're on probation, a simple arrest or something like that can violate your probation. Picking up small little charges violates your probation. I had a friend who was about to be done with his probation and he got charged with something and they violated him. He sat in jail for like 2 years and they ended up finding out that he was innocent. But because he was on probation, it was an automatic violation just from him being arrested. But that state case and that federal case was supposed to be together. So the state originally charged him and Duke with that, after they showed the video of Duke being attacked inside of, what was it, Magic City or whatever, or some club. And after that, him and Yak got in the car and allegedly rode to where the other side be it. And they had things on them, weapons on them and stuff. So the state had that case originally. That's where everybody saw the video from Yak talking to the police. That was him holding up for his charges. However, the feds picked that case up. So it was the same case. The feds just picked it up.
Thank you.
You're welcome, baby. All right, y'all. I got to get back to work because I got a hair appointment and I got to get my work done for the day. I will check in on YouTube. This is my first time going live. So if I did anything wrong, feel free to tell me. If it's something I could do better besides making my baby be quiet, please tell me. Thank y'all for joining. And I'll see y'all next time. Say thank you.
Thank you. Thank you.